Okay, so time to move on to how we actually make the law. And to that, we're going to look at the process that is involved in making a law and the bodies that make them, our legislature. In the next podcast, we'll look at those who administer at the executive and the judiciary, but let's concentrate on how we actually make a law. Okay, so to understand who gets the right to make a law, we need to look at the Constitution. Then we're going to look at both the bodies that make the law, the legislature, and the process that they go through in just a little bit of detail. Following that, as I said, the executive and the judiciary. So that by the end of this, we have an understanding of the Australian Constitution and how we divide the powers between the various governments that we have. We'll understand the structure of the parliaments, both federal and Queensland, how laws are made and deadlocks resolved, understand what the executive does, the court hierarchies that we have, the court processes, the role of tribunals, and alternative dispute resolution, understand what that is, and ADR techniques. So we've got our readings there, and let's get started. So one of the most important documents that we have in Australia around the law is the Constitution. There's many sections to the Constitution, and it sets out several things, and you can see in this table here. What it really does is it says who can actually make the law, who has the power to do certain things in the executive government and the judicature. So it sets out those separation of powers and the principle of responsible government. You can also see that it gives certain powers to the federal government, and that's what we're really concentrating on in this particular podcast. It also sets out and preserves those elements of the state constitutions and laws so that they can remain in place as well as having the federal sphere of government and how we can alter the Constitution. Let's concentrate on the main parts. Okay, this is probably the kicker and the critical one. In terms of what the federal government can make laws about and what the state government can make laws about, we need to look at section 51 of the Constitution. And in fact, here's section 51 of the Constitution here, and you really should get it out and have a look at the Constitution sometime. A very important legal document. And what you can see is that it sets out that the Parliament shall have the power to make laws with respect to, and you can see that it lists all the things that the federal parliament can make laws with respect to. For instance, subsection 5 there, postal, telegraphic, telephonic and other like services, so all of our telecommunications. You can see here that what we end up with is three sets of powers. We have exclusive powers for the Commonwealth as set out in the Constitution. We also have exclusive powers for the state, and that's everything that's left over at the end of reading the Constitution. And in the middle, we have these concurrent powers, these section 51 powers, which are set out here, which both levels of government can make laws about. However, if there's a dispute around the concurrent area, the federal laws actually apply. So they kind of trump them. A bit like statute trumps case law, federal trumps state, provided they have the exclusive power and or provided it's a concurrent power. If it's not listed in the Constitution, then the federal parliament can't make a law about it. Education is an example where they can't actually regulate state schools, etc., which is why the states look after that area. Okay, so hopefully you've got that idea. The idea that we have exclusive, concurrent, and residual powers. The residual powers are state government owns, so they're kind of exclusive, but we'll call them residual because they're what's left over. So what else do we know? Well, we know about the trumping, that the federal law will trump state law, provided it's within the scope of the powers as set out in the Constitution, and therefore the federal government can't make laws about everything it wants to. It can only make laws about those things that are actually contained in the Constitution. If we wanted to change the Constitution, what would we do? Well, it's a little bit of a complicated process, as this slide sets out. What we'd have to do is get an absolute majority of both houses of Parliament. Then it has to go to all of the people in Australia, all the people who can vote. What you get is a referendum. And for that referendum to get up, you need a majority of all the people in Australia to vote yes, and a majority of people in a majority of the states to say yes. Now, the reason that they did this was so that a very populous state, a state with lots of people in it, or a couple of states with a lot of people, as it couldn't vote for a change of constitution to the detriment of those other states that didn't have a lot of people in them. And so for that reason, we have this rule that it's the majority of Australians, plus also a majority of Australians in a majority of the states that's required. As a result of this complexity, and also because people really don't like change a lot, we find that very few constitutional changes have actually got up.